Fulton County government provides essential services to county residents and the public at large. Every county division or department has a unique responsibility to meet the needs of surrounding communities. Yet, for the Fulton County workforce, county buildings and facilities are more than locations where public services are rendered. Each office cubicle, fire station, police precinct, public works assignment, clinic, or service center is a dynamic, multifaceted, and complex workplace. Fulton County employees have a tremendous responsibility to ensure that every workplace is a safe environment and free from all forms of harassment, including sexual harassment. What you know about sexual harassment and learning how to prevent sexual harassment in the workplace is important. Prevention begins with you, and helping the county to eliminate sexual harassment in the workplace is your responsibility. Module 1, Prevention Begins with You, explains why sexual harassment prevention is important and explores behaviors that constitute sexual harassment and the significance of sexual harassment prevention. In this module, you will refresh your knowledge of the county policies and federal laws prohibiting sexual harassment and learn the importance of sexual harassment prevention in the workplace. Prevention efforts typically seek to reduce or deter specific or predictable problems, protect the current state of well-being, or promote desired outcomes or behaviors. Prevention is the most effective weapon to combat sexual harassment. Harassment does not disappear on its own. In fact, it is more likely that when the problem is not addressed, the harassment will worsen and become more difficult to remedy as time goes on. The burden of preventing sexual harassment rests on both the employer and employees. How can sexual harassment be prevented? With the use of positive, proactive measures undertaken by Fulton County through providing education, by participating in sexual harassment prevention training, and fostering an understanding of what behaviors constitute sexual harassment, expecting employee professionalism and exercising self-control, increasing awareness through managerial monitoring for inappropriate behavior, and promoting early intervention by providing immediate counseling if inappropriate behavior is detected. Sexual harassment can be prevented. Why is prevention important? An environment free from the harmful stressors associated with harassment helps to create and maintain a safe and congenial workplace where everyone is treated with dignity and respect. However, prevention requires more than mere attention to courtesy and respect. It is important for Fulton County to address sexual harassment because it is a violation of an individual's legal rights and has a negative impact on all employees. Everyone has the right to work in a respectful environment free of sexual harassment. Prevention promotes professionalism, avoidance of legal implications of sexual harassment, and enhances Fulton County's reputation as a desirable place to work. It is important to prevent sexual harassment because it is a violation of Fulton County policy and individuals' legal rights and has a negative impact on all employees. What is the cost of engaging in sexual harassing behaviors? Sexually harassing a person is an assault on the person's dignity, a mark of disrespect, and demonstrates an inability of the violator to conduct oneself in a professional workplace. Other negative effects and related costs of sexual harassment include lower productivity of employees, higher costs due to lower efficiency, increased absenteeism and turnover, court awards, settlements, and fees, damage to an employer's public image, deterioration of staff morale and a decline of organizational climate, disciplinary action, and possible termination. So, what constitutes sexual harassment? Is it asking a coworker out on a date, putting your arm around someone as you're talking, hugging a colleague you haven't seen in a long time, telling someone you like what they're wearing, discussing your sex life with a coworker? Do any of these behaviors appear sexually harassing to you? Would this behavior offend someone you know or work with? How can you be sure? Workplace relationships are very complex, and there are no easy answers. Before you attempt to answer these questions, let's discuss how the law and county policy define sexual harassment. According to Title VII of the Civil Rights Act as amended and Fulton County Anti-Harassment Sexual Harassment Policy 100-30, sexual harassment is a form of sex discrimination. Specifically, sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal, physical, or nonverbal conduct of a sexual nature that affects an individual's employment status, opportunities, work performance, or creates a hostile environment based on sex. Learning the core elements of sexually harassing behavior is critical to preventing sexual harassment in the workplace. Unwelcome or unwanted sexual conduct is the most important element of sexual harassing behavior. Thus, any verbal, nonverbal, or physical conduct that is of a sexual nature, perceived as offensive, and unwanted by the person the conduct is directed to, can constitute sexual harassment. Verbal conduct of a sexual nature can be calling a person a girl, hunk, doll, babe, honey, sweetie, whistling at someone or catcalls, making sexual innuendos, turning work discussions to sexual topics, telling sexual jokes or stories, asking about sexual fantasies, preferences, or history, asking personal comments about a person's clothing, body, or looks, repeatedly asking out a person who is not interested, making kissing sounds, howling, or smacking lips, telling lies or spreading rumors about a person's sex life. Nonverbal conduct may also be perceived as sexual harassment, such as looking a person up and down, staring at someone, blocking a person's path, restricting or hindering the other person's movements, following the person, displaying sexually suggestive visuals, artifacts, or items, displaying sexual or derogatory comments about men or women on coffee mugs, hats, or clothing, making facial expressions such as winking, throwing kisses, or licking lips, making sexual gestures with hands or body movements, giving letters, gifts, or materials of a sexual nature, hanging around a person, crowding someone's personal space. Physical conduct that may constitute sexual harassment are massaging a person's neck or shoulders, touching the person's clothing, hair, or body, hugging, kissing, patting, and stroking, touching or rubbing oneself sexually around or in the view of another person, brushing up against a person, patting, goosing, caressing, or fondling, gestures or sounds, making sexual pleasure, desire, groaning sounds, tearing, pulling, or yanking a person's clothing, exposing oneself. Last, it is important to note that the harasser's intent is unimportant. It is how the conduct is perceived by the person to whom the conduct is directed that determines whether the behavior is considered sexually harassing. Furthermore, sexual harassment is not gender-specific. This form of sex discrimination can involve parties of the same sex or the opposite sex. Women can sexually harass other women, and men can sexually harass other men. And recently, the courts have expanded their view of what behaviors may constitute sexual harassing behaviors as related to lesbian, gay, bisexual, or transgender individuals under Title VII. In a case brought by the Equal Employment Opportunity Commission, it was decided that an employee's failure to conform to sex stereotypes, meaning to act in accordance with preconceived notions of manly or womanly behavior, was protected under Title VII. So, for example, repeated comments directed to a male coworker such as, "That's gay," can rise to the level of sexual harassment and constitute a violation of Title VII and Fulton County policy. It is important to remember what constitutes sexual harassment and the consequence for engaging in sexually harassing behavior. Sexual harassment is unwelcomed sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Individuals of the same sex can sexually harass each other, and harassment based on LGBT status may be a form of sex-based harassment. Fulton County has numerous reasons to encourage employees to prevent sexually harassing behaviors in the workplace. In addition to ensuring that employees work in a healthy environment, the county has significant responsibility to uphold federal guidelines that prohibit sexual harassment. Sexual harassment is a form of sex-based discrimination, and Title VII of the Civil Rights Act of 1964 as amended makes discrimination in employment based on a protected class, such as sex or gender, unlawful. Sexual harassment is a form of sex discrimination and is covered under this statute. In addition to federal mandates, Fulton County Policy 100-30 specifically makes sexual harassment a violation. It is important to note that Fulton County's policies are broader than the federal law when it comes to determining whether certain conduct is considered sexually harassing. In other words, if you work for Fulton County, your behavior can violate county policy, even if the behavior is not illegal. Many county departments include sexual harassment as a violation of their standard operating procedures as well. If you violate county policy, you could also be sanctioned for non-adherence to departmental policy. Sexual harassment policy violations are enforced by the county manager or the appointing authority pursuant to Personnel Regulation 1800-2, Articles 13 and 21. Fulton County policy provides that disciplinary actions for engaging in sexual harassment may range from a written warning to dismissal, depending on the severity or frequency of the behavior. Remember, sexual harassment is unwelcomed sexual conduct that is perceived as offensive. Anyone, regardless of gender and gender identity, can be a harasser or a victim of harassment. Harassers can lose their jobs and be subject to civil and criminal penalties. Sexual harassment is preventable. It's up to you. Now that you have completed Module 1, let's put your knowledge to the test. What is sexual harassment, and why is prevention important? Sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal, physical, or nonverbal conduct of a sexual nature that affects an individual's employment status, opportunities, work performance, or creates a hostile environment based on sex. Prevention is important because prevention ensures employees and managers effectively utilize and employ education, professionalism, awareness, and early intervention, such as counseling and correction, to rid the workplace of sexually harassing behaviors. You have now reached the end of Module 1. Please join us for Module 2, Recognizing Sexual Harassment in the Workplace.